of Tim's book, The Right to Earn a Living, is available out in the lobby, and he'll be signing copies after tonight. So I'm sure all of you, 100% of you, won't buy a copy of the book, but I hope some of you will buy a copy of the book. So we appreciate you all coming out tonight. Tim Sandefur is a principal attorney at the Pacific Legal Foundation. As the lead attorney in the foundation's Economic Liberty Project, he works to protect businesses against abusive government regulation. He also works to prevent the abuse of eminent domain, having litigated important eminent domain cases in California, Missouri, and elsewhere, and having filled briefs in many significant eminent domain cases across the country. He has been published extensively and has appeared regularly on TV and radio shows. Tim actually appeared at the Dole Institute. He and I weren't sure if it was May of '07 or of '08, so we'll leave that one open-ended when he talked about his previous book on eminent domain. And Tim, we're very glad to have you back. Please welcome Tim Sandefur. Before we go to the book, before we get into the crux of that, talk to us a little bit about how you got interested in the law and a little bit about your background and where you went to school.
Well, I was in college in Michigan at a school called Hillsdale College, and I heard a speech given by a lawyer named Clint Bullock, who came to speak about a case that he had recently worked on in San Diego, California. And this is a case where his client was doing, she ran a business doing hair braiding for clients, traditional African hair braiding techniques. She wasn't a barber. She didn't cut hair or treat hair or style it or anything. Just did this hair braiding. But the state of California said that was cosmetology, and that in order to do that, she would have to first have a cosmetologist license, which required 2 years of training, learning how to do various kinds of hairstyles that had been out of date for many years, and a whole variety of other skills. The trial court later found that more than 95% of the required curriculum was utterly irrelevant to the trade that she practiced. Nevertheless, if she were to go into business doing hair braiding for her customers, that would be a violation of the law, and she could be charged with a crime for that. Fortunately, that law was challenged as unconstitutional, and she won that case. And when he told this story, I thought that is what I need to do. Because I'd already been thinking about doing law, because I'm attracted to the big philosophical issues of the role of the state and individual rights and things. But in the law, you can apply those principles in real life and put them into practice. And here was an area that I could go into where I could work to protect the rights of America's entrepreneurs, of America's wealth-creating individuals, who are the people I admire most. It's the best part about my job, is getting to meet these amazing people who have the guts to go and start their own business. You know, I would never have the courage to do that, and I'm amazed by people who do that. So I decided there and then that that's what I wanted to do for law, for a career rather, and I went to law school at Chapman University in Orange County, California. And shortly after that, I took a job at the Pacific Legal Foundation, where I run our Economic Liberty Project, defending entrepreneurs against that kind of ridiculous licensing law or laws that prohibit them from lowering their prices and other kinds of restrictions on economic freedom.
Okay. Why did you write this book?
Well, there's very much a need for this book. The right to earn an honest living, the right to earn a living by applying your own skills at a trade to provide for yourself and your family without unreasonable interference from the government is, when you look into the history, a cherished right with more than 4 centuries of common law precedent behind it. The oldest case on the subject I found is from the 14th century, but it really picked up steam in the early 17th century, in Shakespeare's day. Courts started saying that every English subject had a right to earn a living without unreasonable interference by the government. And this was one of the bedrock principles of American constitutional law for a very long time, until about the 1930s. And about that time, courts started ignoring the freedom of economic choice and saying that government could intrude on the freedom to make economic decisions for yourself about what jobs to take, what businesses to start, what wages to earn, what hours to work, and allowed legislatures to take this freedom away from people to an increasing degree. And in all the time that's passed, so far as I know, there's only one other book on the subject, and that's Bernard Seagan's classic 1980 book, Economic Liberties and the Constitution. That's one reason why I dedicate my book to him, because he was really a pioneer in this area of legal research, of recovering these principles that had been forgotten by the law school community.
I want to come back a little bit later to the 30s and some of the court decisions, because I know you write at length about that period of time and some of the things that were done, but I want to cover some basic background first. Talk a little bit about this. Do you feel that political and economic freedom can exist separately, or can they only exist in combination?
I think there might be efforts to have the two things exist separately, but they can't last for very long. A classic way of putting it is that you can't have a free press unless you can own a press. If the government owns all of the press, owns all the machines, then how could you possibly hope to have a free way of expressing yourself in print? And the more restrictions there are on property rights and the freedom of economic choice, the less opportunity there is for political freedom. Now, political freedom is also secured not only by private property rights, but by the opportunity to earn a living for yourself and your family, which is one reason why the authors of the 14th Amendment, when they wrote that amendment, hoped to protect economic liberty for the newly freed slaves, to give them the opportunity to stand on their own 2 feet and not depend on a racist white power structure. Now, unfortunately, their attempt failed, largely because of the U.S. Supreme Court. But it was by allowing people the economic freedom to build up their businesses and things that then people could take the next step of protecting themselves against attempts to deprive them of their political rights. So I think that economic freedom and political freedom are deeply related. At bottom, they're the same right, which is the freedom of choice. It's the freedom to decide for yourself what you want to do in terms of economics. You know, we talk about freedom of religion. What is freedom? Freedom of religion is the right to decide for yourself what faith to follow, what church to go to, and so forth. And it ain't nobody else's business if you do. And when we talk about economic liberty, it's the same thing. It's the right to decide how to run your business, what business to start, or what to charge for your services, or what to earn, how long to work, and it ain't nobody else's business if you do.
So what you're saying, I think, in essence, is that freedom of religion, freedom, political freedom, freedom to spend the money you earn the way that you choose, not the way somebody tells you to, those 3 things are essentially the same. They're all freedom of choice in your view.
Thomas Jefferson once said that freedom, that he defined freedom as the ability to decide for yourself what to do with your ideas and your faculties and your mind, your religious beliefs, your political opinions, within the boundaries of the rights of other people. As long as you respect other people's rights, you have the right to run a business, or if you don't want to run a business, you know, to work for somebody else or whatever. In the same way that you have freedom of religion or freedom of political choice. And a government that's going to deprive you of the opportunity to run your own business has set the precedent for depriving you of other rights of choice.
What are the protections in the Constitution for Americans' right to earn a living?
Well, there are a number of them, but there are 2 that are the most famous. One is the Privileges or Immunities Clause of the 14th Amendment, and the other is the Due Process Clause of the 14th Amendment, which also appears in the 5th Amendment. The Privileges or Immunities Clause, when you look at the history, and I go into this at length, not only in my book, but in a recently published law review article in the New York University Journal of Law and Liberty. When you look at the history of the Privileges or Immunities Clause, it's quite clear that one of the rights, one of the privileges or immunities of citizens of the United States that was protected by that amendment was the right to earn a living for yourself and your family without unreasonable interference from the government. The Due Process Clause was also used because the term due process of law is actually synonymous with an old phrase from the Magna Carta, the Law of the Land Clause. And the Law of the Land Clause was the provision under which those old English cases that I mentioned earlier, that's what those were decided under. As far back as 1602, there was a case called the Case of Monopolies, where it was illegal for anybody to make and sell playing cards without permission from the government. And this guy went and made and sold playing cards and was brought up on charges. It went up to the English version of the Supreme Court. And the court held that that monopoly was illegal or unconstitutional under the Magna Carta's Law of the Land Clause. And that began a legal tradition, the Whig anti-monopoly tradition, that prohibited the government from restricting some people's economic opportunities in order to benefit a favored class of insiders. And so those 2 provisions are the most famous protections for economic liberty in the Constitution.
Mm-hmm. Let's go back now. You mentioned a few minutes ago how that your feeling is that the Constitution was severely challenged by the Supreme Court by a variety of decisions in the 30s. Talk a little bit about that. I think you outline in your book 4 specific ways that the Constitution was challenged.
Yeah, what happened was in 1934, the Supreme Court decided a case called Nebbia versus New York. Now, it has to be made clear, there really are no such things as sudden, dramatic changes in the law. The law changes as a result of gradual change in philosophy, in economics, in morality, changes in social arguments that gradually work their way up to the Supreme Court. So it's not like everybody woke up one day and this was the way things were. What happened in 1934 was the climax of the progressive movement that began in about the 1880s. And this was a group of intellectuals who radically altered how the constitutional structure works in this country. And their 4 big ideas were: rights are just permissions that government gives you. The American founders thought that rights belong to you because you're a human being, and no just government may deprive you of those rights. But the progressives believe that rights are permissions that government gives to you for government's own purposes. So, for instance, Oliver Wendell Holmes wrote a famous opinion called Abrams versus United States, where he said, it's famous today as supposedly a free speech opinion. But the first line in it is, persecution seems perfectly logical to me. He then goes on and says, but we don't persecute people because it's good for society to have a debate, so we allow people to debate things. And then, when we want to, we can shut them down. So he also wrote a case called Schenck versus United States, where he said it was okay to throw somebody in jail for handing out pamphlets protesting against a military draft. And that case is most famous for his line, yelling fire in a crowded theater, because, yeah, handing out pamphlets protesting the draft is just like yelling fire in a crowded theater. Right? Holmes was a great enemy of liberty and certainly one of the worst human beings ever to serve on the Supreme Court. Anyway, the second great progressive idea was government exists to make society nice. Right? The Founding Fathers thought government exists only to protect our rights. That's what they say in the Declaration of Independence. That's what Jefferson said in his first inaugural address. He said, "The sum of good government is one which shall restrain men from injuring one another and leave them otherwise free to regulate their own pursuits." But the progressives believe that government exists to make society fun to live in. Right? So they came up with these radical new programs for how to make society nice. Segregation, eugenics, prohibition, the income tax, the use of eminent domain for redevelopment, and other vast government programs to shape society. The third great progressive idea was judicial restraint, which means that when the government violates your rights, courts should stand back and do nothing about it. I'm sorry to say a lot of my conservative friends believe this idea too. And one of the great examples of judicial restraint in recent years is the Kelo case. Right? In Kelo, the government steals somebody's property and gives it to a private developer, and the court says, we're not going to do anything about it. That's judicial restraint. Right? And then the fourth great progressive idea was the living Constitution. The Constitution changes over time. It doesn't mean today what it meant yesterday, and so forth. And Louis Brandeis, who was a progressive Supreme Court justice, he famously said, property and other rights of the individual must be remolded from time to time to meet the changing needs of society. I love that line because I love the word remolded. A great euphemism for violated, right? Oh no, we're not violating your rights. We're just remolding your rights in the interests of society. Right? Now, if it can be remolded, it's not a right. We would never allow somebody to say, well, we're going to remold your freedom of religion to meet the changing needs of society. Right? But that was the progressive attitude toward economic freedom, private property rights, and so forth. And those ideas boiled along until 1934, when in Nebbia versus New York, the Supreme Court made that into constitutional law by creating what lawyers call the rational basis test. And that's the test that courts still use today